Guy Rufus Huddleston's defense was that he was an innocent dupe. A truck driver he had met a few months earlier, Leroy Westby, asked Huddleston to help him sell thousands of blank video cassettes. Karen Curry's boss told her to help Huddleston sell the tapes, but she was suspicious. After Huddleston assured her the goods weren't stolen, she moved 5,000 tapes. She also called the police every day until a stolen property report finally turned up and the FBI contacted Curry. That's not in the Supreme Court opinion, but that's what happened. When Huddleston offered to sell a truckload of kitchen appliances, he thought he was speaking to another merchant. Robert Nelson was an undercover FBI agent, though, and he arrested Huddleston when the stolen appliances were delivered, along with Westby, who was driving the truck. It turned out that Huddleston had earlier sold 4 dozen televisions, also supplied by Westby, to a record store owner. Huddleston was charged only with selling and possessing the stolen tapes. The only issue at trial was whether he knew the tapes were stolen, which is an element of both charges. Each of Huddleston's deals with Westby makes it harder to believe that Huddleston had no idea any of this merchandise was stolen. The appliances in the videotapes had been reported stolen, but there was no similarly concrete proof that the televisions were stolen. Huddleston argued that for that reason, the televisions should not be mentioned at his trial. Rule 404B restates the common law rule that evidence reflecting bad morals can be admitted if it is relevant to something other than a propensity to be bad. This is important, as Huddleston illustrates, because in many cases, criminal intent can be proven only by showing a pattern of behavior that implies willful misconduct. The common law authorities, however, sometimes disagreed about how strong the evidence that each act in the pattern actually occurred needed to be. In Huddleston, the government could not prove by clear and convincing evidence that the televisions were stolen. But while the case remained pending, the Sixth Circuit lowered the applicable standard to a preponderance of the evidence and then affirmed Huddleston's conviction. The Supreme Court held that the judge did not have to decide at all whether the government proved that the extrinsic act occurred. It makes no difference if the judge is personally convinced by the evidence or not. What matters is whether the jury could rationally believe that the extrinsic act occurred. The judge's role is only to ensure that the proponent's evidence regarding the extrinsic act is strong enough that a jury could rationally conclude it occurred. Rule 104 encapsulates the common law on preliminary questions of admissibility. Preliminary questions of admissibility are issues concerning foundational questions. The rule specifies the judge's role and the jury's role in determining whether a foundation to admit evidence has been laid. The judge decides all the legal issues concerning admissibility, including whether the evidence complies with all the rules of evidence. Whether the rules are satisfied is always treated as a legal question, even though some rules raise mixed issues of law and fact. When a judge has to decide a mixed issue, such as whether a witness knows the defendant well enough to give an opinion about his character, the judge has to be convinced by a preponderance of the evidence. Purely factual issues are for the jury, including issues about foundational facts. In this case, the fact that Huddleston sold some television sets is relevant to the government's case only if those television sets were in fact stolen. Whether the TVs were stolen is a foundational fact, because if they weren't, those sales have no bearing on the government's case. They are irrelevant. The jury has to decide whether the TVs were stolen, but no one needs to explain the concept of preliminary questions of conditional relevance to them. People intuitively know to disregard irrelevant information. If the jury is not convinced that televisions were stolen, they will not fault Huddleston for selling them. The judge's role on preliminary factual issues is limited to keeping the parties from introducing evidence about things they can't even arguably prove. The judge decides whether there is enough evidence to arguably establish a disputed foundational fact. Rule 104 says that if the jury could rationally believe a foundational fact, then the evidence gets admitted for the jury to consider. Whether the proponent's evidence is substantial enough to reach the jury is a legal question, just as whether the terms of any rule have been met is always a legal question for the judge to decide. The better reasoned cases decided under the common law agreed with the formulation codified in the rule. Judge Learned Hand, for example, explained in 1935 that a person who repeatedly bought stolen goods from the same person was more likely to know that the goods were stolen. The earlier purchases are competent evidence, and it is for the jury to decide whether the person actually knew the goods were stolen. Huddleston was accused of selling stolen goods rather than buying them, but the principle is the same. The government's case as a whole showed a series of suspicious, related transactions that cumulatively afforded the jury a basis for believing the TVs were stolen, just as the videotapes and the appliances were. The evidence about the televisions, considered in isolation, may have been a close call, but considered with the other evidence, it wasn't. Because relevance turns on the case as a whole, Rule 104B specifies that the foundational facts can be supplied after the jury hears the evidence that the foundational facts support. This allows the parties flexibility in presenting their case in whatever sequence is most effective or feasible. As a practical matter, the jury figures out how much weight to give the evidence in secret, relying primarily on its own common sense and ability to reason things out. In theory, the jury can accept extrinsic acts evidence that is more likely true than not. It can consider that evidence in deciding whether the accused is guilty of any charges beyond any rational doubt. If the jury believes the accused is probably guilty, but wouldn't bet a lot of money on that, then the verdict is not guilty. An acquittal means the sovereign failed to prove the defendant's guilt. Not guilty does not mean innocent. That raises the question of whether an act that someone was accused but acquitted of committing can be brought up at a later trial on other charges. The Supreme Court decided in Dowling v. United States that acquitted conduct can be introduced under Rule 404B. The court first held that because an acquittal means only that there was some doubt about whether the defendant committed the act charged, there could nonetheless be enough evidence for another jury to decide that he probably did. Even if the jury in Reuben Dowling's other case had a reasonable doubt that he was with Delroy Christian in Vina Henry's home, that doesn't mean he wasn't. The court went on to hold that to keep the evidence out, Dowling had the burden of proving to the judge that he was never in Ms. Henry's home, and he failed to prove that. The evidence that he was there could be used to show he knew Christian, who was seen at the bank when it was robbed. But if collateral estoppel never applies to 404B evidence, then Part 2B of the opinion would seem to be superfluous. Looking to Justice Brennan's dissent adds to the confusion. The dissent says that the majority decided first that Dowling did not prove that the first jury doubted that he was in Ms. Henry's home, and second, that collateral estoppel does not bar using acquitted conduct. But the majority opinion has those issues in reverse. This probably means that the dissent was responding to an earlier draft of the majority opinion. If we switch the sections of the majority opinion, we start to see the problem. If Dowling couldn't prove that the jury did not believe he was ever in Ms. Henry's home, then the doctrine of collateral estoppel is not even implicated, and there's no reason to decide its scope. Justice White's opinion hints at a possible explanation. It tells us at the end of Part 2B that Dowling's lawyer conceded during oral argument in the Supreme Court that the record is unclear about whether Dowling's identity played any part in his acquittal. Let's listen to that.
When you were asked before about whether the identity issue was foreclosed by collateral estoppel, you said there were two problems there. And one of them was that the burden should be on the government to show that the issue was not raised. You had a second point you're going to make, and you never made it. Do you know what it was?
I suggest, yes, Justice Stevens, I suggest that there are several indications in the record that, in fact, the issue of identity may well have been raised in the prior trial. We have the and I assume you just want me to answer based on what's in the record. I am in possession of some other information in the court's files as to the resume of the first trial and the witnesses that were called and that sort of thing. It also casts doubt on the government's assertion that issue that identity was not
enough in the record, is there? If we disagreed with you on burden of proof and thought you had the burden of proving that the earlier judgment did actually decide the specific matter that the government seeks to use this evidence for, would you not agree that the record isn't sufficient to say you carry your burden on that? Do I make myself clear?
Yes.
Yeah. Maybe there's a lot of stuff out there that if you had a retrial you could do that. I don't think in the present state of the record we can really tell whether the jury verdict in that case determined that your client was not the person who went to that woman's house.
I think a fair answer to that question is indeed the record is not clear. Either way, that's why we would like you to put that burden on the
issue
government.
really is if you don't lose on the difference in the burden of proof, the issue on collateral estoppel would be who had the burden.
The issue on collateral estoppel would be who had the burden.
The government says you should because you're relying on it, and you say they should because it's unfair to do it otherwise.
Part 2A, then, was decided in violation of the doctrine of constitutional avoidance. There was no reason to reach the double jeopardy question in this case. The case was decided when Justice Stevens pushed Dowling's lawyer into admitting the record was unclear as to what happened in the first trial. And Part 2B is obiter dicta. It resolves an issue that doesn't matter in this case and that can never come up again after this case. It doesn't matter who has the burden of proving what happened at the first trial, because collateral estoppel never bars acquitted conduct offered under 404B to prove anything other than an ultimate fact. The very first sentence of Part 2B confirms as much, because it couches that section of the opinion as an alternative holding. As the nation's court of last resort, the Supreme Court has no reason to make alternative holdings. It's also strange that Part 2A assumes, for the sake of argument, that Part 2B of the opinion doesn't exist. The court assumes that the first jury acquitted Dowling on identity grounds, and in the next section holds he has the burden of proving that and can't. The majority was very motivated to hold that acquitted conduct can be admitted under Rule 404B to prove anything other than propensity.